So let's have a look at this. Now, for the non-fatal offenses against a person, what we're really looking at is things like the battery, assault, wounding with intent, um, grievous bodily harm, assault occasioning grievous bodily harm, those offenses, right? So we're gonna start off with assault, and I'm wondering now if we are more responsive now, so you guys can tell me what assault is. What is assault?
Any act that cause an individual to feel immediate fear.
Immediate fear. Okay. So it's anything that causes them to be in fear of themselves, right, or their property, anything like that that allows them to, feel some fear thereabouts. So we're looking at a state of affairs, right? So it involves any intentional or reckless threat. So it could be intentional or reckless, right? Or use of force against another person that causes them to feel immediate bodily harm. Well, fear immediate bodily harm, or offensive contact, right? So that is generally what it talks about. It doesn't necessarily require physical contact, so that's one thing that you guys need to know. We don't really need physical contact. That's not what assault is, right? That would be battery or something else, right? Once they touch you, it's not assault, right? It's going to be some form of battery, some other type of component, but the fear that you feel, right, or that a person would feel, that would constitute assault. So, actus reus of assault, we're looking at the interaction, the intentional or reckless act by the defendant that can cause the victim to apprehend immediate unlawful violence, right? So importantly, assault does not necessarily require physical contact, as we stated. It occurs through threats or actions that create a reasonable fear of intent to harm, right, the victim. So looking at anything that may make the victim fear that they are going to be harmed, right? So the accuracy of race of common assault, no, that's a different thing. So common assault is a broader offense, right? That encompasses various forms, non-serious physical violence or threats of violence against another person. It may include actions that cause minimal injury or no injury at all. We're generally looking at the common assault, right? So okay, at something like that. So for the mens rea of assault, no, we know the mens rea of assault is we are actually looking at the intentional mens rea or the reckless mens rea, right? So persons can actually intentionally um anything that if you want to intentionally cause the fear, right, within the victim, then that would be intentional, right? So whether or not it's specific intent or oblique intent, right, intentional mens rea is a part of the mens rea for assault, and reckless mens rea as well, right? Anything that recklessly discarding a substantial or unjustified risk that the defendant actions will result in the victim's fear, right? So you may not intend, but due to reckless actions, it makes the victim fear, right? Or instills a feeling of fear within the victim, right? So we're looking at those aspects. The main case law that we come upon when we're talking about assault, we have this: the origins of recklessness is given in Cunningham, right? So you should know where that comes from. RV Vina is a wonderful case that we use here. So in this case, the police were called to restrain the appellant and others who were creating a disturbance in the street. During a scuffle, a police officer sought, let me let that person in. A police officer sought to arrest him. The appellant kicked out, resulting in the fracture of a hand of one of the police officers. The appellant was convicted for assault and appealed. Right? His appeal was dismissed. The Court of Appeal, the Criminal Division, approving the direction of the judge that the first instance who had found him, right? That at first instance, right? The judge at first instance, right? Who had found that the appellant had been reckless as defined in Cunningham, right? So he's being detained and he was continuing to kick out, punch, and just he was basically being restless, right? While being detained by the officer, right? That allowed the officer to actually be in fear for any type of harm. So what if he kicks him? What if he hurts him, right? and it actually hurt the officer, right? In that case, it would be assault and battery, but we're looking at the assault component of RVV now, right? And it was most definitely there, right? We're looking at the fact that not only, well, words alone don't normally constitute assault, right? As we can see in Tuberville v. Savage in 1669, right? That's another case there, right? So we're looking at the fact that words alone, right, cannot constitute assault, right? So we're looking at it from that perspective there. Anybody knows this case? Tuberville v. Savage, 1669. Go ahead.
Is that the case where the man puts his hand on the sword and says, if it were not for the fact that it was time for court, I would use this against you?
Okay. So it's a part of that. Yes. Well, not. Is it that case? That would be RV Light. Wouldn't that be RV Light? That would be RV Light, right? Because one moment, right? So looking at Tuberville v Savage, right? It's basically the accused lady's hand, right? Oh, it's actually a part of it. It's the same thing with RV Light. Yeah, so you're actually saying the actual right thing. So the accused would lay his hand on the sword, right? And it says, if it were not for the SC's time, right, I would not take such language. So you are actually right, completely right. Okay. The thing is not. It's similar to that of R.V. Light in 1857, right, where the accused was held guilty for an assault by raising his sword over his wife's head and saying, if it were not for the bloody policeman outside, I would split your head open, right? That is RV Light. So RV Light can be used here, right? It's not unpopular, but RV Light can be used here. So Tuberville v Savage and RV Light are similar, in which in both instances involving swords, both instances involving words that at the time did not necessarily constitute assault, right? It was the action of carrying the sword and brandishing the sword, that action that constituted the assault, not necessarily the words, right? But words were said to be able to constitute assault in RV Ireland, 1998, right? Where the defendant was convicted of assault when he telephoned his victims a number of times, right? And then remained silent. The assault in this case was said to have arisen because the victims would not have known what the accused was going to do next, right? I may have feared that he was about to come around to their house and attack them. So it was just accusers continuously calling the victims, right? And remaining silent, right? So it could have constituted assault in that case for RV Ireland, right? But we have assault as well with no intention of physical harm done by Lockdown v DPP in 1976, right? Does anybody know that case? That was the case in which the defendant would have shown the complainant, right, a pistol in a jar and told her that he would hold her hostage. So the woman was terrified, and the defendant then told her that it was not real, not a real pistol, right? But the thing is, right, is the fact that he told her, right, that it was a real pistol. He was acting as if it was a real pistol and telling her that he would keep her hostage. That creates a specific instance. Which case would you like me to repeat before I continue? Which case? Lockdown VDPP?
So this is what we were just talking about.
RV Light? Okay, the one that I was just talking about, right? Actually was Lockdown VDPP. LOG, right? The last one on the slide, Lockdown VDPP.
Okay, sir, thank you.
No problem. So he basically was trying. He showed the victim a pistol in a drawer, right, and told her that he was gonna keep her hostage and all that other stuff, right? The instance in which she felt fear for imminent bodily harm is assault, right? After though, he told her that it was fake, right? But that was ultimately assault because the minute she apprehended the immediate and unlawful fear for personal violence, right? Then it would constitute assault. Alright? For battery, however, now we look at battery being the physical component of it, right? Battery usually follows assault, but battery doesn't have to follow assault, right? It involves the physical act of touching of another person in a manner that is harmful or unwanted. So if it's unwanted, it's still battery. If it's offensive or harmful, it is still battery, right? We're looking at those things. Battery is a common law offense and is often associated with assault, which involves the apprehension of immediate harm. So this is always they always say assault and battery, right? Because usually something is happening to make you fear, right, physical harm, and then the physical harm is done, right? So usually assault, a battery accompanies assault, right? But there are instances in which they do not accompany each other, where out of the blue you are physically harmed, right? So you wouldn't have the time to develop the capacity for assault, right? So that some things like that can occur, right? The mens rea for battery, you need to have intentional and reckless mens rea. The same thing for assault, right? So you can intentionally, with purpose and desire, to hurt, physically harm the victim, right? Or you can actually take an unjustifiable risk, right, to create a state of affairs with your actus reus to actually hurt the victim, right? So different ways you could have it intentional, whether it be specific or oblique, and you could have reckless. All right. You have exemptions from battery hover. The while battery involves the intentional and unlawful application of force to another person, there are circumstances or exemptions for defenses that may apply in specific circumstances to battery. All right. Properly conducted sports or games within these games, along as it is permitted, right? Battery is not going to be taken, right? So in the context of organized sports and games, participants may consent to physical contact that would otherwise constitute battery. So those type of stuff, right? So in different types of contact sports and stuff like that, wouldn't constitute battery. All right. Body piercings as well, right? Body piercings typically exempts the person from typically exempts the person performing the piercing from liability and battery. So you need consent. The person that is giving you a piercing needs consent to do so, right? If they pierce the skin, technically that's breaching skin, allowing for blood or anything like that. Any breach of skin, that would be wounding with intent, right? And it would be battery as well. So, in the case of actual body piercings, where you go to the person, there is an agreement to get pierced, then that would not constitute battery, right? Consent. Courts considered branding as an exemption in R.V. Wilson, 1996. What was occurring in R.V. Wilson? Does anyone know the case R.V. Wilson? Okay, so I don't hear anybody saying anything to it. So R.V. Wilson, 1996, it was basically the victim in the case, right? Mrs. Wilson asked her husband. No, it's not that. Oh, it's not ringing a bell. Okay. So the victim, Mrs. Wilson, asked her husband, the defendant, to brand his initials on her buttocks with a hot knife, right? He complied. So Mr. Wilson now took the hot knife and branded his name, right? Sorry, his initials into his wife's buttocks, right? Basically, right? Then now, imagine you ask for this, and then after the pain, now you go to straight to court, right? There was a complete litigation around this issue, right? After she asked for the branding, And the Court of Appeal quashed Mr. Wilson's conviction for assault occasioning bodily harm, right? It was the view of the court that what was done was no different and more dangerous than tattooing. So it was dismissed here, right? We also have the issue, right? A third exemption, right, would have been we could have rough horseplay. That would have been one as well that I don't have in here, right? So that would be R.V. Jones, 1987. It's not in the PowerPoint, but let me just write it in chat. That would be Jones, R.V. Jones rather. R.V. Jones. And that would be 1987 or 97, one of them. 87, right? So the former schoolmates of the victims would have tossed them in the air, and one boy suffered a broken arm and a ruptured spleen. Basically, they usually played together and they played roughly, right? And then one of them fell. That will not constitute battery, right? So rough horseplay will not constitute battery either. Alright. So looking at that, the court ruled that there was genuine belief that consent was given for the rough horseplay, right? And there was no intention to commit an injury, right? That rough horseplay. So I put it in there in the chat, right? And the case there is going to be R.V. Jones, 1987. Surgery as well. Consent to medical procedures, including surgery, exempts healthcare professionals from liability for battery. However, the consent must be informed, voluntary, and obtained in accordance with medical ethics and standard practice, right? So in the case of medical treatment, no, that would constitute battery, right? Consensual and consensual and non-violent sexual conduct, right? So consent to sexual activities exempts individuals from being liable to battery, provided that the activity is consensual, non-violent, and does not exceed the scope of the agreed upon interaction rather. So we have the consent, right? We have that consent must be freely given and capable of being revoked at any time. However, intention, right, harm greater than assault or battery will attract a conviction. R.V. Donovan, 1934. In this case, right, we have where a girl was beaten as a form of sexual perversion, and the court was deaf to the plea that she had consented to the conduct, right? It was held that it was an unlawful act to beat another person with such a degree of violence that the infliction on the bodily harm was a probable consequence, right? And when such act is proved, right, consent is immaterial. So yes, consent can be given, but it depends on how far these issues are going, right? Because there are a lot of different things that persons do for sexual perversion, right? But if it goes too far to constitute a harm greater than assault and battery, it must consent itself will become immaterial, inconsequential, right? And then the court will take it out. All right. So we're looking at that. R.V. Brown. In R.V. Brown now, we'll look at this case. So in this case, the court cited 3 principles as to why it was against public policy to cause intentional bodily harm in such a manner, right? Sexual manners, generally, right? So we have the risk of infection and spread of disease such as AIDS, right? What was happening in R.V. Brown, by the way? In R.V. Brown, we had a group of middle-aged men willingly participated in sodomistic activities which involved intentional infliction and wounds, right? So videos of were made of their activities and circulated in members groups, and the House of Lords generally took it up, and the court noted that the harm caused was deliberate, and the fact that victims consented did not make the act unlawful. So it's not in every instance that consent will wipe away the liability, right? So they're arguing that it would increase the risk of spread of different diseases, right? It was only luck that the participant only left up to luck that participants did not suffer, right, from any serious harm or infections for their activities, right? whilst of the fact that the participants might withdraw their consent or might not have readily consented to the degree of harm imposed, right? And there was the danger that young people could be drawn into these unnatural practices. These are all going to fall under morality and the law and religion and the law. Alright? Here we have RV Emmett 1999, right, which is a case that we have there that follows Brown. What happened in RVM 1999 now, right? We had high risk sexual activities between a heterosexual couple resulted in one occasion of hemorrhage in the eyes of the victim and another burns to her breasts. The Court of Appeal ruled that the consent was no defense. The harm caused was deliberate, and the fact that it was dangerous to the health and well being of the victim. This harm was deemed serious enough to invoke the public policy principle that is the protection of individuals by extension of the protection of the public from harm, even from themselves. So we're looking at those type of things within sexual contexts, right? So battery can still come out whether or not consent is given, right? And what's happening here now, I'm not sure if anybody remembers the principle from module 2, right? But what's happening here now, even though it's consensual and it's between two individuals, right? If there is significant harm to members, right, of the public, then the government, the crown, will gain locus standi, right? So that's how it became a public matter. That's how it fell under public law, right? Criminal law there, right? So because there was significant harm and damage to a citizen under the jurisdiction, the courts, right, had locus standi, alright? Necessity as well, right? Necessity would have been a defense. In certain emergency situations where immediate actions are required to prevent greater harm, the defense of necessity may exempt individuals from liability or battery, right? This defense typically applies, right, when the action taken is reasonable and proportionate to the threat posed by the emergency, right? So, for example, let's say that there's a pregnant woman in the car and there is a health complication, she needs to reach hospital immediately, right? Breaking the red lights are going to be illegal, right? But it was necessary for you to do so, right? So you have some that would be an example of necessity. So in the case where it was necessary, right, to do perform some of these actions to probably hit somebody physically or something like that that will constitute battery, right? Necessity, right, would have been a defense that. So if it was necessary to do so in order to prevent further harm, then that would have been a suitable defense. Right? It's a complete defense, by the way. Necessity absolves. Right? Lawful correction in loco parentis. So what we're talking about here is that individuals acting on loco parentis, such as parents and legal guardians, may use reasonable force to discipline or correct their children. So in the Commonwealth Caribbean, it's actually alright for parents to beat their children and stuff like that, to correct their children. But when it goes too far, right, greater than the appropriate circumstances meted out by the Child Protection Acts across the Caribbean, then it becomes illegal, right? So there's a certain place in which parental correction of children passes their place, right, and becomes a matter of serious bodily harm or wounding that will now constitute battery, right, and be taken up by criminal law. Right, so yes, there is some amount of power and freedom in loco parentis, right, when legal guardians or parents are disciplining their children, but it can go too far, and when it goes too far, the courts must take it up. Right, we're looking at that. Intoxication is not a defense of battery, by the way. It is not a defense. In criminal law, intoxication refers to the state of impairment caused by the consumption of alcohol or drugs. While intoxication may affect the individual's judgment, coordination, and behavior, it is generally not considered a defense to criminal liability for offenses such as battery. The rationale behind this principle varies depending on the legal system, though. So it may vary depending on which legal system you're in. But in many jurisdictions, battery is classified as a crime of basic intent or specific intent. So it's really basic, right? Which means that the prosecution does not need to prove that the defendant intended, right, to intended specific consequences of their actions. Instead, it is sufficient to establish that the defendant intended to commit the crime or the act that resulted in the harm or offensive contact, right? So it's basic intent, right? So it doesn't matter what if you're intoxicated or whatever, that will not save you from battery, right? So we're looking at that. It depends on the jurisdiction though. Depends on the jurisdiction, right? The actus reus for battery now, we know the actus reus constitute any type of physical action or any behaviors undertaken by the defendant that will result in the harm, right, or offensive contact of another person. We're talking about actual physical contact that may harm another person, right? That is generally the actus reus here. There are different elements of the actus reus, the application of force. So the actus reus of battery involves the intentional or unlawful application of force to another person. So this force may be applied through various means, including striking, punching, kicking, pushing, or any other physical action that will result in contact with the victim. So remember, we're talking about contact. Alright? Contact with the victim, no, right? So body requires actual physical contact or touching of the victim by the defendant's actions. Right? The contact may be direct or indirect. So you can either touch somebody, like hit somebody, or you can throw something and hit somebody. That will still be battery. You shoot somebody, that would still constitute. Well, it wouldn't constitute battery unless it's not harmful at all. It would probably be wounding. Because if you shoot somebody, blood probably is drawn, and that would be wounding. Alright? Without consent as well. So if consent is not freely given, and you touch somebody, right, or cause physical harm, then it can constitute battery depending on the severity of the matter. Alright? So we're looking at those type of things. Any harmful touch or physical interactions that may result in harm, it would be battery if it has no consent. And we spoke about earlier the limitations of that consent. Harmful or offensive contact, we generally talk about that. So it's generally recycling everything. You would have the intent and or recklessness, right? That would be actually in under the mens rea, and we're talking about the actus reus now, right? So that should be fine. Physical injury worse than battery now. So wounding. Wounding is a lesser offense compared to causing grievous bodily harm and involves the unlawful, maliciously inflicting of a wound upon another person. Right? That's wounding in general, right? Wounding with intent, however, right? You speak about the fact that you this is actually a serious offense, right? So it involves actually causing a wound to another person with specific intention. So wounding here would basically speak to oblique intent or recklessness, etc. Right? Wounding with intent now speaks to when there's specific intention to wound, right? Intention to wound or cause grievous bodily harm, or the intent to resist and prevent the lawful apprehension or detainer of any person, right? So those things could constitute wounding, right? Constitute wounding. A wound is defined as a break in the continuity of the whole skin. So once the skin is broken, it is wounding. If it is not, it is battery. So once blood is seen, it is wounding. If not, it is generally, right? I have to use generally very sparingly here. Generally battery, right? Causing grievous bodily harm now. We're talking about grievous bodily harm. GBH refers to serious or significant injuries that result in long-term or permanent harm to the victim, such as broken bones, severe lacerations, or internal injuries. Things that bring them closer and closer to death. So the closer to death you get, the more grievous the bodily harm. Right? So usually the chronic issues resulting from this action is grievous bodily harm. Right? We also have inflicting grievous bodily harm, right? Specifically. So this speaks to the specific intent of providing this. So it's talking about no grievous bodily harm, but with the proof of specific intent to harm another to this extent. Right? However, it doesn't necessarily require proof that the harm was inflicted unlawfully or maliciously, meaning that defendant intends to cause harm or acted recklessly, knowing that their actions could result in serious injury. Right? So you can have specific intent and it can be without specific intent. It just looks at what this side looks at what grievous bodily harm is, and now we're looking at how it is inflicted onto a person, right? So generally with specific intent, right, it would probably get a higher weight of punishment. But if it is done through oblique intent, or generally just as creation of a state of affairs that may produce this, whether it's reckless or malicious, right, then that would still be grievous bodily harm. We have assault occasioning grievous bodily harm now. Where assault occasioning grievous bodily harm occurs, right, it's really an offense that involves unlawful or maliciously inflicting grievous bodily harm upon another person, right? Unlike the offense of just causing it with intent, the offense does not require proof. So we're looking at that as well, right? So if you assault somebody now, it's talking about the assault thing. So you can actually commit grievous bodily harm without assault, and this assault occasioning grievous bodily harm speaks to the fact that the person being assaulted, no, the assault actually resulted in grievous bodily harm. So it requires proof that the defendant assaulted the victim, and that the assault resulted in grievous bodily harm. Right? There are issues in which persons can fear for their life and end up causing themselves damage, right? So that's actually probable, right? The case law, the cases that we previously discussed, speaking about um any type of battery, wounding, grievous bodily harm, anything like that, we can find them in RV Savage, DPP versus Paramenta, and R versus Pratt, which was discussed before, right? Which we stated before, right? When we were looking at murder and manslaughter, right? Assault occasioning grievous bodily harm, we have R.V. Roberts 1972. Right, so here the accused gave a lift in his car late at night to a girl. He began to make unwanted advances of a sexual nature to her, which alarmed her. She feared that he intended to rape her, and while the car was moving, she opened the door and jumped out, injuring herself. Notice that there is where we have assault occasioning grievous bodily harm. So it's not that the person did the grievous bodily harm specifically to the victim, but due to the assault, right, and the fear for her life, right, she caused grievous bodily harm to herself, and that was Robert's fault, right? So R.V. Roberts, that was the example there. Grievous bodily harm, right? Another case here is R.V. Martin. The defendant put out the lights in the theater shortly before the end of a performance. So he turned off the lights in a theater before the end of a performance. There was panic and persons were injured in attempting to escape. There is no evidence that he intended to cause any harm to anyone, but he was still convicted of causing grievous bodily harm, because we know that we don't require specific intent to charge with grievous bodily harm, as we stated before multiple times, right? So those are the cases, and those are the different offenses, right, against a person which are non-fatal. All right. So those are them. Any questions? Any concerns?